underage children, in order to seek any sort of immigration benefit for a parent, they have to be 21 first. So before they're going to be applying for an immigration benefit or try to get an immigration benefit for a parent, they have to be 21 to act as a petitioner on that case. And even then, it's going to be difficult for some people, because then it's going to determine whether they're allowed to apply here or whether they have to apply in their home country, and whether the 3 or 10-year bar will apply to them, and whether there would be a waiver available if the 3 or 10-year bar did apply. So that's a frequent misconception that we have to deal with a lot. Another one is that people believe that they had children and their children have particularly serious medical issues and need treatment here, and that's somehow going to lead to some sort of immigration benefit being granted. And usually not. There is significant humanitarian parole that can be granted, but in most cases, you're not going to see, just because you had a child here who has some significant health problems, that's going to lead to somehow getting an immigration benefit.
The short answer to that is no. U.S. citizen children cannot petition for their parents until those children are 21. And even then, if the parents are in the United States, entered the United States illegally, unless the law changes, that's going to require departure by the parents. And when they depart, they're going to have the 10-year bar. So as a result of them having been here unlawfully for more than a year, when they leave, they're going to get that 10-year bar. And they will not have a qualifying relative to file a waiver. That requires either a parent or a spouse who is a U.S. citizen or permanent resident. So that is probably not going to work. A lot of people may be thinking of cancellation of removal, that if they have U.S. citizen children with a significant medical issue, then that may provide the basis for cancellation. And it may, but you have to meet all 4 requirements. So that would be physical presence for 10 years, good moral character for that period of time, no significant criminal history, and exceptional and extremely unusual hardship. But a medical issue or a disability alone of a child does not provide a basis for immigration benefits. It might, however, provide the basis of a request to exercise prosecutorial discretion. So if there is a significant medical condition with a child, we can ask the Immigration Service to exercise their discretion and either not initiate removal proceedings or not go forward with them.